Pure corporations, last call, including LLCs, and this is from Studicata. First of all, let's talk formation. In a regular C corporation, when is the corporation formed? That's right, when the articles are filed with the Secretary of State. And they must state the name of the corporation, the maximum number of shares that are authorized, and the names and addresses of the board of directors, the incorporators, and the registered agent. Okay, number one, name of corporation, maximum number of authorized shares. And of course, the board, the incorporators, and the registered agent. All right, bylaws. This is, remember, bylaws are just the written rules of conduct initially adopted by the board, providing for the ordinary business operations and regulating the affairs. If there's a conflict between the bylaws and the corporation's articles of incorporation, guess what governs? That's right, the articles of incorporation will always govern. How about amending the bylaws? The shareholders may amend or repeal the bylaws, and the directors may also amend or repeal the bylaws unless there is some express shareholder agreement to the contrary. Remember, conflict between the bylaws and articles of incorporation will always govern, and they may be amended by who? That's right, the shareholders or possibly the directors if they're permitted to do so. Pre-incorporation transactions. Remember, the promoter will be liable on contract as long as both parties know that the corporation has not been formed. And remember, the corporation is under no duty to adopt or ratify that contract. What do we need for the promoter not to be liable on contract? A novation, in which that corporation specifically released the promoter from liability. Or indemnity. The corporation agrees to indemnify the corporation. Okay, remember, promoter will always be liable on contract unless there is that or the promoter obtains indemnity. The corporation itself is not bound by any pre-organization contracts. They can simply adopt them by accepting the benefits of the contract or ratify them. Okay, let's go to piercing the corporate veil. So, state up front, the shareholders are not at risk. The directors and the officers are liable when the corporate veil is pierced. So, when do we pierce the corporate veil? When there's some sort of harm to the corporation or when there is a creditor of the corporation. And what do we need? We can pierce the corporate veil under the domination theory. So there's the mere instrumentality. The corporation or the LLC is just a mere instrumentality of its owner. And so there's that unity of interest and ownership. 2, the domination theory, in which one shareholder or director completely dominates the corporation such that it lacks a will of its own. The corporation doesn't follow the corporate formalities. And remember, undercapitalization, serious undercapitalization, is a ground for piercing the corporate veil. When does this happen? Serious undercapitalization such that you can't do things like buy liability insurance. It was inadequately funded at its inception. Or, most important, fraud or illegality. Okay, most of the time, your passive investors are not going to be held liable. So piercing the corporate veil, 1, is the corporation an alter ego? 2, is it a mere instrumentality? Someone has dominated the corporation such that it lacks a will of its own? Is the corporation used to sanction fraud, promote injustice, fraud, illegality? Was it undercapitalized from the outset? Or did it fail to follow the corporate form? For example, by failure to inform yourself. Okay, let's talk financing. Remember, we've got our common stock and our preferred stock. Now, preferred stock will pay that stated dividend, but it doesn't always have voting rights. The deal with voting rights is that all shares in the same class must have the same voting rights. Okay, we know about authorized shares. That's what the corporation is authorized to issue. And the outstanding shares, we know outstanding so outstanding can never exceed authorized. Treasury stock the company has bought back. And remember, options for purchase of shares can never exceed the authorized shares. You can't issue options that exceed the number of authorized shares. Okay, preemptive rights. This is kind of fun. The preemptive right is a shareholder's right to maintain their fractional share of a corporation before outsiders are permitted to acquire those shares. So, preemptive rights, the corporation has to opt in to create preemptive rights. This is most states. They have to expressly provide for preemptive rights in the articles of incorporation. Most states, most jurisdictions, the corporation must opt in and create those preemptive rights, which will allow shareholders to maintain their fractional interest. Okay, so no preemptive rights for preferred stock that you can't convert to common stock, and no preemptive rights for, you guessed it, directors, officers, and employees. Directors, officers, and employees don't get preemptive rights. That would be what? A conflict of interest. Okay, how about dividends and distributions? Dividends are declared at the discretion of the board. A shareholder has no right to a dividend. It's discretion of the board. A corporation cannot fail to declare a dividend in bad faith, but holding on to corporate assets in the name of growth of the corporation is going to be fine. Okay, so shareholder meetings. What do we have? We have our annual meeting. That's a must. And then we have special meetings, can be called by the shareholders on demand, the board of directors for limited purposes, or anybody else authorized to act. So you can call a special meeting. The shareholders may demand one. The board of directors may call one for a limited purpose, for example, dissolution. A special meeting is going to involve something like sale of substantially all the corporate assets, mergers, acquisitions, fundamental transactions. What do we need for a meeting? Oh yes, notice. Notice. Special meetings, annual meetings, you're going to get notice of that. For a special meeting, you have to state the purpose of the meeting and provide notice, minimum 10 days. Special meeting, what's the purpose of this meeting? 2, notice, 10 days minimum. And of course, we have to have a quorum. And a quorum is, of course, just a simple majority. All right, voting rights. All shareholders' rights are counted equally regardless of class. And what about that record date? The shareholder is only entitled to vote if he held shares as of the record date. What's the record date? 70 days, no more than 70 days prior to the shareholder meeting. The record date is no more than 70 days prior to the shareholder meeting. That's our record date. How many days? 70 days prior to the shareholder meeting. Go buy your shares 70 days before the shareholder meeting. Cumulative voting. This is easy. There's straight voting and then there's cumulative voting. Cumulative voting means you get to cast as many. If you own 100 shares and there are 3 seats, you get to cast 100 shares per empty director seat. Voting by proxy. Everybody can vote in person, but most shareholders will vote by proxy. And a proxy is a person, and it can also be a document, an appointment form. So the proxy is freely revocable by the shareholders. If a person agrees to act as a proxy, it's freely revocable unless the proxy also holds shares. If the person designated as a proxy also owns shares, the proxy is not revocable. But otherwise, a proxy is revocable. Distinguish this from a shareholder agreement, which is just a contract like any other, allowing a person to vote providing that people will vote their shares in a certain way. Okay, just remember, a vote by proxy allows the shareholder to vote without physical attendance. It can be any kind of writing, even an electronic, an email or something that is signed. It's freely revocable unless the proxy is a person and they also own shares. Inspection of books and records, so easy. You can inspect the books and records for any proper purpose related to your interest as a shareholder. How about the articles of incorporation? Hey, that's public. Anyone can inspect that. So what do you need to do to inspect the books and records? Just make a written demand, give them 5 days to respond, and regular business hours. Inspect the books and records, any proper purpose related to your interest as a shareholder, your financial interest. What must you do? Make a written demand, 5 days notice, and you can't be inspecting those things at midnight. Okay, the authority of the board of directors. The directors have full control, and they must have a quorum to take action. Okay, so notice of a director meeting is presumed, but if the directors call a special meeting, they of course must provide notice. And 2 days is enough for notice. And what do the officers do? Day-to-day management. Okay, let's get into the meaty stuff. Duty of care and the business judgment rule. What is the duty of care? Directors and officers owe the corporation a fiduciary duty of care. What does this mean? The duty of reasonable care and skill, reasonable steps to monitor the corporation's management, disclose material information, and make reasonably informed decisions. Duty of care, monitor the corporation's management, act in the corporation's best interests, make reasonably informed decisions, with due care, in the best interest, with due care in good faith, due care and in good faith, due care and in good faith. Remember, once we hit the duty of care, this implicates the business judgment rule. A violation of the duty of care means an action taken in bad faith. The business judgment rule operates as a presumption that the directors are exercising their duty of due care and placing the interests of the corporation ahead of their own at all times. A court will not second guess the decisions of a director or officer if those decisions are made in good faith, with due care, and in the best interests of the corporation. What is the business judgment rule? The directors are acting in good faith, with due care, and in the best interests of the corporation. All right, so we breach the duty of care by a showing of bad faith misconduct. And in such a case, remember, the burden shifts to the directors or officers to prove, that's right, the transaction was entirely fair to the corporation. Now, remember, the corporation can limit liability, personal liability, but they will never indemnify a director for bad faith misconduct. Bad business decisions, that's one thing. Bad faith misconduct, you are going to get a derivative suit. Okay, duty of loyalty is always going to go to, that's right, secret profits, avoiding conflict of interest, or making money at the expense of the corporation. Okay, so when do we have a conflict of interest? Well, when someone is a party to a transaction, selling their own items to the corporation, or they have some sort of beneficial financial interest in the transaction, or they're usurping a corporate opportunity for themselves. Now, remember, you can usurp a corporate opportunity if all material facts are disclosed or known to a majority of the disinterested directors, a majority of the disinterested shareholders, or the question can prove, that's right, for entire fairness. All right, well, here I am. Okay, so corporate opportunity. You get a corporate opportunity, a director can take that for their own if they show that all material facts are disclosed or known, the transaction is approved by a majority of the disinterested directors or the shareholders, and in the absence of that, by showing that the transaction was entirely fair to the corporation. Okay, let's talk mergers and consolidation. Mergers is when one company is absorbed by the other, and the surviving entity will govern. The surviving entity's bylaws, articles of incorporation, etc., will govern. And by the way, when you get a conflict of laws question, the state of the merged entity, the surviving entity, that state's law will govern. Okay, so we do have our short form merger, and this is when if a parent owns 90% of the corporation, then you can merge the subsidiary. Okay, so let's repeat that. The short form merger. If a parent company owns 90% of a subsidiary corporation, then that corporation can be merged without approval from the directors or the shareholders. Short form merger. Parent owns 90% of sub. We don't need shareholder approval to get that transaction, to get that. And guess what? Mergers trigger dissenters' rights. Dissenters' rights. Dissenting shareholders have the right to, that's right, fair market value of their shares immediately before the merger or consolidation. And then of course, they lose the right to challenge any of the action. Okay, so we've got our mergers and consolidations, and then we have the other fundamental transaction, which is sale of substantially all the corporate assets. What's required? Shareholder approval. Shareholder approval. Okay. What if so this doesn't apply if selling assets is the corporation's usual and customary course of business. If your business is selling televisions, sale of substantially all the corporate assets is in the usual course of business. But if we're selling all the corporate assets, sale of substantially all the corporate assets, we're going to need shareholder approval for that. Shareholders get to vote on that. Shareholders get to vote on fundamental transactions. Remember, mergers, consolidations, that triggers dissenters' rights. Sale of substantially all the corporate assets. Okay, derivative claims. Remember, a derivative lawsuit is brought by a shareholder on behalf of the corporation, alleging the corporation has been harmed. And the recovery belongs to who? That's right, the corporation. The rule here is demand and wait 90 days. Demand and wait 90 days. Then you can file your derivative action. The old rule was demand again unless futile. The LLC rule is demand again unless futile. Now it is demand and wait 90 days. And of course, the damages from any derivative suit go to the corporation. Direct claims alleges that the shareholder themselves has been harmed, and the proceeds of that recovery are going to go to who? That's right, the shareholder. All right, let's talk LLCs. LLC, so a corporation, we have the articles of incorporation. LLC, certificate of formation. And LLCs have operating agreements, not bylaws. Remember, an LLC is presumed to be member managed unless the operating agreement provides otherwise. Then it will be manager managed. Okay, so the last rule about LLCs is, remember, an LLC still has limited liability. You can't pierce the LLC's assets unless we have one of the doctrines that would allow for piercing of the corporate veil. Same thing. Alter ego, mere instrumentality, serious undercapitalization. Those are our biggies for an LLC. One big thing to remember about an LLC is that in an LLC, okay, I'm forgetting this rule. Oh, that's right. Okay, so an LLC has to have at least one member. A passive investor will not be liable. A couple of little things. So remember, we have our de facto corporation and our corporation by estoppel. Our de facto corporation will protect the corporation if they made a good faith effort to incorporate, and there's just some defect in the articles of incorporation. A corporation by estoppel exists, and by the way, this is true for LLCs as well. A corporation by estoppel exists to protect innocent parties. It's an equitable remedy. So if the corporation contracts with a third party and there's some defect in the articles of incorporation, the court might hold that there's a corporation by estoppel that protects the corporation from the actions of a third party, say an employee, who wants to get at the personal assets of the incorporators. Conversely, if the corporation acts in such a way that it harms a third party, the court may rule that if a corporation is defectively incorporated, a corporation by estoppel exists. And that's it for the highly tested rules for corporation. Oh, I remember the one rule. So an LLC is not dissolved, continues to exist as an entity. And the LLC withdrawing member is not, I repeat, is not entitled to a buyout. And that's corporations.